Hi, my name is David Ruegg. This is the COVID-19 Quadro Topics. This is the re-recording of the hacked version. So thank you for tuning in again. The MCLE credit code for the original version that got hacked was Rick, Dave, John 2020. The MCLE code for this presentation is Rick, Dave, John 2020 clean. So to receive your MCLE credits, you will give the code Rick, Dave, John 2020 clean to the San Bernardino County Bar Association, and we'll be providing details for that. I am a Quadro attorney, and I've been a Quadro attorney since 2011. I am very thrilled to be here with two of my Quadro colleagues, John Madden and Rick Muir. John, if you could introduce yourself, and then Rick.
Yes, John Madden with Muir, Schwartz and Madden. We've been valuing retirement plan benefits in divorce and preparing Quadros since the mid-1990s. And I'm also co-founder of Quadro Counsel, a divorce website designed to take the family law attorney from discovery to judgment. Happy to be here today. Rick?
Yeah, Rick Muir, and I've been doing Quadro since Moses brought the tablets down. So just actually, kind of enjoying it right now. The only problem is, and we talked about this a little bit, everybody's sitting at home, so they've got enough time to call and bug us to help.
Yes.
So, yeah. Anyway.
We're all getting a flood of emails. So let's talk about what happened as a good starting point. Obviously, everybody in the year 2020 is aware of the coronavirus, and it certainly has some impacts on the market. So, John, why don't you, since you have some experience working on the market floor of San Francisco, tell us a little bit about risk and volatility and what that means in terms of expecting values of assets.
Yeah, obviously a massive amount of volatility due to the pandemic and the impact on the global economy. So, as we've all seen, investment accounts, valuations, our own retirement plans, have been negatively affected. And of course, that does translate into family law, which is the purpose of today's discussion. How do we properly navigate and advise clients regarding their retirement plans when you're going through divorce? And we've seen such market volatility. So.
Yeah. So, and why don't you sort of bring down the slides so we can see our heads full facing every once in a while. So, I guess one of the things that family law attorneys will consider in market volatility times, it's a sort of natural reaction, will be, well, if we can't assume the value of assets in these 401k accounts are the same today as tomorrow, why don't we just negotiate a fixed dollar award? Right? It seems like a logical way to handle things, but there can be some traps with that. And actually there are a couple cases, and one of the cases, we have a VIP here who has an inside information. Rick, did you have anything to do with the Jane's case?
Yeah, that was mine. I had the underlying Quadro on that. There's a little background on it. This was a Hemet case with Judge Warren. The wife was owed an equalization payment in effect of $113,000. The judgment was entered in 2010. She was bugging Mr. to give her the money. Finally, she came to see me in 2014, and we did a Quadro, and I put in there that she would get gains or losses back to date of separation on it, on the theory that it was a dollar amount they came to when they added all the assets at date of separation. Mr. wouldn't cooperate, and then he just had Fidelity put $113,000 into an account in her name in the plan. After explaining that it was a prohibited transaction and that he had just made all of the money in the plan taxable to each of the participants, they actually undid that, and then we got down to doing the Quadro. So he wouldn't sign. Mrs. did an RFO to have the Quadro entered. Warren went back and forth on it, but he finally decided, yeah, we're going to give gains or losses back to date of separation. Mr. appealed, and on appeal, the Court of Appeals said, hey, here's really what happens. As of date of judgment, that becomes her separate property. So at least from date of judgment onward, she's entitled to gains or losses on her separate property, and Mr. shouldn't get a windfall for that. So kind of keep that in mind. There was 4 years that passed and a lot more than that by the time this was all decided. Heggie, on the other hand, was a shorter term case. There was a dollar amount that was supposed to be transferred from an IRA in husband's name to an IRA in wife's name, like 45,000 or 47,000. And basically what they did was they took each of their IRAs as of June 30th of one year and said, okay, here's the amount that has to go over to the other party. The judgment gets entered. Mr. had sent for an IRA, and we'll get into this a little bit later, you don't need a QDRO, you need transfer documents and a judgment. And Mr. had completed the transfer documents, sent them to his attorney. His attorney withdrew the day that the judgment came back, was a lot due, and did not forward the distribution documents to wife's attorney. Wife's attorney got a hold of Mr. He said, already forwarded them. They didn't get them. So Mr. called his former attorney. Documents were sent over. So there was about a 3-week gap between date of judgment and the date that she got the forms to fill out and have her money come back. Well, down the road, one day prior to the 6 months expiring, she filed a motion to have part of the judgment set aside, the part that has to do with this transfer. And basically her argument was, look, one of these stocks, there were 2 high-tech stocks in there. One of them had gone up 140%, the other one had gone up 250%. She didn't indicate what the values were at the time that she got her 47,000, which was in November of the prior year. So essentially, the court looked at it and said, you know, they actually looked at Family Code Section 2123, and her argument was the judgment became unequal, the division, therefore you have to set it aside. And the court said 2123 does not allow the court to do that if it's just an unequal division or later becomes unequal. So I think they were really looking more at three weeks wasn't enough to bring this up. So if you look at the 2 cases, depending on how long it's been, the court's going to go one way or the other, but beware that this is out there. So if you really mean a dollar amount, put in and no gains or losses.
Yeah. So Rick, so your perspective is the distinguishing feature of these cases, because they come to totally different results, is simply the passage of time, is your opinion. Okay. Yeah. So best practice would be then to avoid this sort of subjective interpretation of has enough time passed to determine gains and losses or fixed dollar. The best practice would be write in your marital settlement agreements the valuation date and then whether or not it should adjust for gains and losses, correct?
Correct.
Okay. And so, you know, on the other side of the coin, maybe parties don't want to do a fixed dollar amount. They both want to ride the market equally, and that's fair enough. And that's the default rule under California law if you can't come to an agreement on a fixed dollar amount. But that has its own traps as well. You know, when we as QDRO preparers prepare these QDROs, we're kind of doing a time machine to divide the account as a point in time backwards in time. And sometimes the QDRO is left to these third-party administrators to do the calculations. John, have you ever had any problems with third-party administrators not doing correct calculations? Does that ever happen to you?
Yeah. I mean, I would say it's probably happened to all of us. You know, and the big question is whether or not you realize it. You know, but yes, I mean, so again, you know, more times than not, the QDRO is going to say a dollar amount or a percentage, and that's going to be adjusted for gains or losses. And you can certainly let the third-party administrator make those calculations, and at some point you have to. But if it's, you know, 5 years ago, 10 years ago, that this dollar amount is being awarded, even if the third-party administrator can do the calculation, it's usually best practice to have it done prior to the parties signing and entering the QDRO so that everybody can see and approve of the calculation beforehand. Certainly now with the market volatility, possible CARES Act, which we'll get into a little bit later, you know, there's other reasons besides just ensuring that the third-party administrator does this calculation accurately, but there are other reasons why you might want to have this done ahead of time. So why do you want to prepare the tracing prior to signing off on the QDRO? So, account for the market volatility. You also want to make sure that you've checked for recent distributions or loans, which is normally something that you want to be mindful of, but now with the CARES Act, that could be even more so. And again, we'll talk about that in a bit. Reduce the possibility of error by the custodian in calculating that award. And then, so with that last, the error issue, I did have a case where Fidelity was a third-party administrator, and they the QDRO awarded the dollar amount as of 20 years ago, and Fidelity did their calculation of gains and losses. And in that calculation, they had forgotten to award the alternate payee the initial amount. So that was a significant error, which they did correct. But if the alternate payee had not asked me to do my own tracing, she never would have known that. And then in addition to that is really what we're going to talk about right now is the methodology that these third-party administrators oftentimes use is less than ideal in terms of accuracy. So in this example, we have say there's a QDRO that awards 50% of the account balance to the alternate payee at the end of 2012. They each then would get, if there's 600,000 in the account, they each would get 300,000. And then each year there are employee and employer contributions going into the account. Of course, it's after separation, so that all goes to the participant's separate property, and explains why the participant's percentage is slowly increasing and the alternate payee's interest is slowly decreasing. Again, just because there's been post-separation separate property contributions. So that at the end of 2019, you've got a participant, their percentage ownership of the account has increased to about 56.5%. Alternate payees is about 43.5%. And this calculation really should be done ahead of the QDRO. And then the QDRO, instead of saying, 50% in 2012, it's going to award a dollar amount or a percentage as of 2019, and everybody gets to review this calculation ahead of time.
So John, in this breakdown here that you're showing me, how are the gains and losses allocated? What percentage are you applying to each period of gains and losses?
Right. So as you go through, obviously, it starts out a 50-50 split. But then as these, and again, if you do it on an annual basis, that's fine. A quarterly reconciliation seems to be, I think, the best bang for your buck in terms of accuracy versus the cost to prepare the calculation. I mean, on an annual basis, something like this, would only be a couple $100, at least if, we were doing it. So the cost effectiveness of it, I think is, it's really, it's just best practice. But the allocation of gains and losses, again, on an annual basis, we're basically just taking this percentage, and that's the percentage the alternate payee is going to get of the gains or losses. So you run this, and again, if it's quarterly, this is going to be a much longer spreadsheet. But again, the more frequent you do the reconciliation of the account, the more accurate it will be. But even if you did it on an annual basis, if you look at this calculation and then you look at how the actual plan makes the calculation. So this is what Fidelity does. They look at the initial award. So they each get 300,000. They look at all of the contributions the participant made over the subsequent 7-year period. They add them all up and add it to the participant's beginning balance, so that on the first day of 2013, participants already at 59.5% almost, and that's how they allocate the gains or losses. So this really, unintentionally, I think, favors one party over the other. So of course, if there's gains, then that's going to be to the participant's benefit. But if there are losses, then the participant gets the majority share of the losses. So either way you want to look at it, it's just, there's a better way to do it. And of course, I think the cost of having to go back to fix the problem, because again, in this situation, comparing these two tracings, the alternate payee would not have received almost $51,000. so that they would have to go back, to you guys and say, look, what happened? I think I need to amend my QDRO. And then of course, because I think it's important in this example, the alternate pay did not get $51,000 that they should have received. So it's not like they're going back and trying to reach over the fence to grab something more that's really participants. They just didn't get really the full amount that was intended by the QDRO.
So from a practical perspective, obviously the case that you had, I think you said there was like $100,000 that you saved the client, but it was over a sort of 20-year period. It was an LA case that you had. But if it's like a shorter period of time, maybe it's not as important. What's your perspective on that, John?
Right. So what had happened was there was the 20-year period. Fidelity had made the initial error, which they forgot to just add the principal award, which was a few $100,000. Right. So that was just an error, right? Pretty significant. And they quickly, they did quickly correct it without having an amended quad or anything. They just, but then it was the issue of the gains and losses. So,
right.
Yes, I mean, at some point, if you update a calculation, say now through the end of March of 2020, which would be the most recent quarter ending date, and then you have the QDRO entered, and now you're tasking the third party administrator to go from April 1st of this year to the date of distribution, and it does usually happen pretty quickly. I mean, at some point you have to hand over the key to the car, right? So I mean, I think in that sense it's fine. The degree of error is not going to be nearly as significant as a 20-year period. So
right. So it depends how long ago the marital settlement agreement was entered. Okay.
Yeah.
So let's transition to a new topic then. One of the favorites of family law attorney is horse trading, right? Trading house for car or retirement account for another retirement account. And I know, Rick, you've experienced these situations. Client comes into your office and they says, hey, I got 10 QDROs. Can we cut down on your fees and just divide the largest account, and we'll just do one QDRO to cover all 10 accounts. I know I've had that as well. And so I think the takeaways that I want family law attorneys to understand are a couple different things. Number one, understanding a differential in the rate of return. Okay, so if we have a Boeing VIP plan, which is a Boeing 401k plan, and the Boeing employee is heavily invested in Boeing stock, and that's husband's account, and then wife has say a Fidelity 401k account with her private employer, and she's invested in a bunch of index funds. Over the course of the month of April in 2020, when the stock market took a dive, Boeing took a much greater hit than many other companies. And so what you're looking at, let's say husband had 100 grand in his account, wife had 100 grand in her account. If you were to do two separate QDROs, then you would see the proportional split of not only the principal balance in the Boeing account, but also the gains and losses in that account, and the proportional split of the principal balance of the Fidelity account, but also the gains and losses. So, $1 in the husband's Boeing account might now be worth 80 cents, and $1 in wife's account may still be worth 90 cents. And so if you're trading these accounts against each other, you're missing out on the differential in gains and losses. So maybe you save a couple $100 on QDRO fees by not doing the QDROs and saying, oh, well, wife's account's 100 grand, husband's account is 100 grand, just let them keep their own. But you're then shooting your client in the foot for several $1,000s on the differential between the gains and losses. So that's really important, is understanding the rates of return of different accounts. $1 in one account is not the same as $1 in another account.
I actually had this happen just recently where we had a bunch of accounts and she got us balances, excuse me, on all of them at January 22nd. So we have January 22nd, very recent. We put it all in there. And during the time we're running around trying to get the QDRO signed,
coronavirus hits.
Yes.
So, and then it shuffles the numbers depending on what the investments were in.
Yeah, hugely. So we ended up having to do QDROs on everything because you couldn't really offset.
You can't do it. The only alternative, Rick, is you do a separate property tracing for each one of those accounts to post coronavirus. And even then, when you're getting this market volatility of 2% a day, 5% a day, I mean, that's a
Yeah.
crazy amount of volatility. And if you're not exactly invested in the same Vanguard index funds, you are not trading the same assets at all.
Right.
Right. And I think, and you guys, I'm sure, see this. I mean, people sometimes say they want to offset with the one quadro, with the issues, that you just talked about, but they think that quadro is going to track the gains and losses on the other accounts.
Yes.
Right.
And then if you
Can't
do
do
the
that.
offset, and you're trying to update all these accounts to keep the offset current, it's like you're just chasing this rabbit. It's like you just can't do it. And you really, like Rick, you just got to end up doing separate orders.
Well, and the problem is we can't snap our fingers as quadro preparers and get these quadros entered the next day. We got to get them through court. We got to get them processed by the plan administrator. So any numbers that you're running are going to be stale, guaranteed, because you can't get the quadro entered day one and then the money divided day two. You got a window of time of court processing, month and a half, maybe longer right now, with half the court staff under quarantine. And then you got the plan administrators 30 to 60 to 90 days that they take to segregate the funds. So it's just one of those things that you got to think about the fluctuation of the assets during that period of time. The other issue that I think is lost on a lot of clients and family law attorneys too that I talk to is the tax classifications of these assets. So, if I were to say, compare $1 in my house equity versus $1 in my pocket versus $1 in my 401k, I'll take the $1 in my pocket any day because it's worth $1 and I can buy $1 worth of candy with it. But the $1 in my 401k is probably only worth 75 cents after we knock off the taxes I have to pay to Uncle Sam before I can buy the candy with that 75 cents. And the $1 in my house is probably worth, 85 cents or 90 cents after you knock off the capital gains tax that I would have to pay to get that $1 out of my house. So understanding that different tax classifications, and especially I sometimes have clients come into my office and they say, well, here's some Roth accounts and here's some 401ks. Let's just offset it. And I'm like, those are not the same. That Roth account is after-tax money. That's dollar for dollar. That's the value of that account. But the 401k, knock off 25, 35% off that value. And that's the value of that account. So, trading assets, just remember that $1 in a house versus $1 in a car versus $1 in a 401k versus $1 in your pocket, they're not equivalent to each other. And then the other thing that I want to point out with this is the in remarriage of Fonstein case. I think it's important to understand that you can't just say, oh, we'll just figure out the taxes later. The courts, pursuant to this case, cannot consider tax ramifications that are not immediate and specific. What this means is you either need to put together a stipulation ahead of time that says how you're going to treat the tax differential of these assets that you're going to horse trade and offset against each other, or you're going to have to reserve jurisdiction for the court to determine the taxes after come April 15th of the following year when you file your taxes, or July 15th in this year, apparently. So I think it's important to understand those different concepts when you're doing your family law horse trading agreements of you get this, you get this, you get this. So that all being said, if we wanted to do an equalization sort of the clean way, okay, let's say you do want to do a buyout and trade some things. I'd like to pose a question to John. So is it okay to do a separate property trace on like a 401k, come up with a value, do an actuary report of a pension plan, come up with a value, and then just say, okay, let's just trade these against each other. I did my separate property trace. I did my actuary report. What's your perspective, John, on offsetting pensions with 401ks, generally speaking, keeping in mind that there is value to settling a case, right? But at the same time, you got to be mindful of and advise your clients of some risks of doing those sorts of trades. What do you think, John?
Right. Definitely, can you do it? Yes. Should you do it? Probably not. Right. You've got 401k values plummeting, and you've got defined benefit, plan values from the participant's perspective actually going up because of the way defined benefit plans are valued, which we'll get into in a little bit. But, it's really just an apples to oranges. If two people have defined benefit plans and you want to value them both under the same set of assumptions, okay, that a lot of people do that. And at least it's more of an apples to apples comparison. But with a defined benefit plan and defined contribution plan, and again, I think you guys are going to talk a little bit about, the access to liquidity and things like that.
Yeah.
So, those issues come into play as well, not just the straight valuation of the two accounts. So can it be done? Yes. Do we do it? Yes. But do we recommend you do not do that? Yes. It's better to just do separate quadros.
So let's talk about liquidity. A favorite, question that I get all the time, and Rick, you get it too, is, well, can I cash this out? So John, why don't you bring up the slide on the cash out exception? And Rick, what's the difference between, what are those rules with regard to cashing money out of 401ks, or can you cash out from an IRA account? What's going on here under normal rules? And then maybe, John, you could talk about the special case, coronavirus rules. But Rick, Go ahead. What's normal time rules for cash out?
Obviously, unless it's a Roth, when you take the money out, you're going to pay taxes. Doesn't matter whether you take it out now or when you're 110, you're still going to pay taxes. Generally speaking, if you take it out before 59 and a half, you're going to pay a 10% federal penalty, 2.5% state penalty on top of the taxes. There are some exceptions to that, one of which is for quadros. And essentially, if a quadro is done and the non-employee alternate payee receives the money, they'll pay taxes on it, but no early withdrawal penalty. The same doesn't happen on the other side. So if the employee participant takes out money, they're going to be subject to the taxes and penalties. And we get some of these where, the spouses get along pretty well, and they say, okay, here's what we want to do. John wants to get 50 grand out of here, and Sue says, I'm fine with that. So we give Sue an extra 50 grand, and then they've got a side deal. I don't want to know about it because the IRS.
So the problem with that, though, is the taxes, right, Rick? How does that work with the taxes?
You can either gross it up for whatever taxes that Sue would be paying, so that it's a net 50, or she pays whatever the taxes are, and the net amount goes to John. But the big deal is the step transaction problem, because if the IRS comes in and finds out that's what happened, they will reverse that and make Mr. pay taxes and penalties and taxes at his rates. Yes.
You think so? Has that ever happened in one of your cases before?
It's not happened in one of mine, but I've seen tax court cases where that has.
Really?
Yes.
Okay. Interesting. So keep that.
You just don't want to know about
on the down low.
Okay. Yeah, exactly.
Okay. All right. Fair enough. Keep it on the down low. So, but during this time, we have some other ways to access liquidity because of the CARES Act. John, you did a little research on the new CARES Act rules. What are they? Could you run them by? And I think we got a slide on it too.
Right. So, it's basically, you want to, participants now have access to additional money. So, you were not able, if you were an active employee, to take a distribution from your 401k plan. You could take a loan up to $50,000. Now you can take a distribution or a loan up to $100,000. And again, this is all, only because of the CARES Act, which was as a result of the pandemic. So that was sort of the reason I was saying before about doing the tracing, so that, because again, if you have a quadro that, say, was just entered and had an award date from sometime last year even, so not that long ago, you would think that should be okay. But then there's a CARES Act distribution or loan, there may be insufficient funds in the account now. So that could obviously cause the rejection of the quadro at no fault of really anybody's, but you just need to know that ahead of time. And that's kind of what, with this slide, the courts are closed. So, if you're in the midst of
mostly
a divorce,
closed,
mostly closed. They're starting to open up again, which is great, and there's a huge backlog. But, if you're in the midst of dealing with the divorce and you have a quadro, in the family law attorney, and you're concerned about, a CARES Act loan or distribution, what do you do? I mean, a lot of plans say you have to join them, but then, not all plans will take or, require that. So, notice of adverse interest, which, to you guys, I mean, that's something that you do not have to file with the court.
Do you think that the notice of adverse interest would prevent and I don't know the answer to this question. Do you think it would prevent a distribution for a CARES Act application if you did a notice of adverse interest? Or you think you just do it to protect yourself as the attorney to say, look, I tried?
I think both of those things. Number one, I tried. And number two, send it along with a copy of Marriage of Baker. Okay. Which is where once the plan was joined and they were on notice of an adverse interest, they paid Mr. out anyway, and they ended up having to pay twice.
Right.
So when you send that along, in an abundance of caution, the plan will probably put on. Normally, they put on at least a shorter time period of 90 days or 120 days for a hold. I think now they may put on a longer period of time because nothing's open. You can't get into court.
Right. And I think we have some templates of the notice of adverse interest. Certainly, if you email me or you email Rick, I think you may have a copy too. We'll give any attorney a copy of the notice of adverse interest so you can use it. With the CARES Act too, I think it's important to note that it's this window of time is, I don't know if we have it on the slide, but I believe what I read in the regulations is it's from January 1, 2020 to December 31, 2020. So it is a sort of window of time that this can happen. And then you do have the option of sort of paying it back over the next 3-year period of time. And you can sort of, if you want to spread out taxes over the 3-year period of time, I believe the IRS codes do allow you to do that as well. But starting in 2021, at least if Congress doesn't make any more changes, we're going to go back to the old rules, which was the slide that Rick did before about what you can and can't cash out. And then you're blocked once again in 2021 from cashing out from IRA accounts. So really, the exception to the cash out penalty normally only applies to 401k plans. But in this year, 2020, because of the coronavirus, it applies to IRA accounts as well. So let's transition to what you don't want to cash out. Have either of you guys ever had a client ask you to cash out a CalPERS account? Has that ever happened to you? I hope not.
We get them quite frequently, and I have a letter that I send to them saying, here's the problem and here's what you're doing, and I want you to sign this so that I've told you this and you still wanted to do it.
I make them sign my letter too, Rick. Believe me, I worry very much. And John, you as the valuation expert, I think you have some more insight on this. So why don't you take it away and explain to us why you don't want to cash out a CalPERS or a CalSTRS account?
Right. And, it's unfortunate, I think, for all of us that, a lot of these public retirement plans don't do a great job at explaining what the lump sum really is, so, and the clients don't know. They think, okay, I could take it monthly or I could take, a lump sum. I'll just take the lump sum, right? I mean, and I don't blame them for having that thought, but there's really no one from the plan's side telling them, well, this is really like 13 cents on the dollar if you take it, right? And then, so it's not a great do. So I think just getting into this whole lump sum, why it's not good in terms of a public plan, we'll just quickly run through, who funds these things, how they kind of work. So for a defined benefit plan, and this is also, I think, a point of discovery that you guys, I'm sure, see is, a lot of private defined, companies with defined benefit plans, they're entirely funded by the employer. So the employee never pays into it. And a lot of times, surprisingly enough, they don't even know they have one.
Exactly. I think that happens with the Kaiser plans a lot. They don't even know that they have them.
Yeah. And there's so many, there's so many Kaiser plans. It's just crazy.
Yeah, right.
So, again, at no fault really to the participant, they don't even know they have this, probably one of the most valuable things they have in all of their, list of assets. So those types of plans are usually funded entirely by the employer. Public plans, PERS, Orange County, STRS, they are funded by both employee contributions and employer contributions. And all those contributions go into the pension trust. and they earn investment return, and that's all there, the big pot of money to pay future pension liabilities. So this is the area that we see all the time that you see almost every day. It's the colossal error of assuming that the employee contributions represents the total value of the public pension when it's not even close. So this is just a typical CalPERS member statement that shows that a member has about 16.6 years of service. They are a safety member under, and there's like 30 something different formulas, but they are under the 3% at 55 formula. And during their employment, they have contributed with interest $167,000. So the point that we're saying is that a lot of judgments will incorrectly assign a value to the participant member's CalPERS being $167,000 when that's just the amount that the employee or the member paid into it. If they leave those contributions on file with CalPERS, then they can take a monthly benefit. But if you elect a lump sum, all you get is the 167. And that is actually reflected on a lot of their member statements. It says that the contributions paid into the pension trust by the employer are not reflected on the member statements. So you're only looking at what the employee themselves have paid into, and the amount they pay into depends on their bargaining agreement. And if it's a different public plan, like one of the county plans, it might depend on the date that they were hired, things like that. So it varies depending on the type of plan. But again, if you leave your member contributions on file with PERS and you take it as a monthly benefit, you're going to get a monthly benefit based on your years of service, your final average salary, and what we call the age factor. So this example, the member is 55, they get 3% of their salary, of their final average salary, times their service credit. So they're going to get a monthly benefit of about $4,500, which in terms of value for a lifetime with cost of living, that's worth about 1.3 million, which is significantly more than 167,000.
So update your malpractice insurance policy if you're going to recommend they cash it out.
Yeah.
Right. I mean, unless you had like terminal cancer or something. I mean,
well, it's funny because I've had that happen in the past, and they said, "Look, I'm not going to live that long. I'm going to Tahiti. Cash it out." So yeah.
And I mean, again, if you have a non-member, and maybe and again, if something horrible like that were to be the facts of the case, and they wanted just to take the lump sum, knowing they're taking 13 cents on the dollar, so be it, right? I mean, that's their decision to do so. But if they do that, the member, has the ability to basically put back what the non-member voluntarily cashed out and reinstate those service credits to sort of recapture all of the employer money, and they should do that. I mean, it's,
yeah, that's the thing. If they do cash it out, then the member probably what they want to do is do a rollover from their 457B plan, their deferred comp, straight back into the CalPERS. And then it's as if they were never married to begin with. It's like they were a single person. They restore the entire value of the pension if they do that.
Right. I would gladly pay 13 cents to get $1 back. And
and where do you get that 13 cents from, John?
Right. So this is what they call the CalPERS buck. This is on their website.
On CalPERS website.
Yes.
Okay.
And same with Orange County. So they, not all the, the retirement systems have taken the time to put this elaborate dollar bill together. But a lot of them have, but what this is saying is that, on average, for every dollar that CalPERS pays out in retirement benefits, 13 cents of that dollar was funded by the employee, 29 cents was by the employer, and then the rest is investment return.
Right.
So this is why I keep referencing the 13 cents. And again, if you have a non-member and they say, well, I called PERS and they told me I could get a lump sum, they're only going to get that 13 cents.
It's a nice visual to send to your client.
Yes.
I use it all the time because, you could talk for an hour and this illustration just
hits it home.
Perfect. Yeah. And again, so it's just not CalPERS. Here's one for Orange County. This is from their website. Same thing, but for Orange County, it's about 16 cents. So, obviously very heavily subsidized, very valuable benefit.
Okay.
Yeah. So that's
All
why
right.
you cash out. You just get the monthly and go from there.
Let's transition to a new topic. Let's talk about risk and when you're making moves that are too risky, okay? Because I know, at least for me, I mean, I watch my 401k accounts and I see things happening and I'm like, oh my God, should I pull the money out? Should I put it in? Should I put it in oil stocks? Oil stocks are really cheap right now. Should I do this? You know, and it's a tough thing, and you get very emotional, especially when it's your own money, and you tend to make bad decisions when you're emotional. So, you know, there's a couple cases that give us some guidance on this in the context of family law. There's the Camgar case and the McTierney case, and these cases are in the material. We printed them in full for those listening in to read the whole cases for themselves, and we encourage that. So the Camgar case. Husband thought of himself as a sort of Warren Buffett type, I guess. He really liked to play with money. And his wife was nice enough to say, all right, fine, you want to play around with money, do some fancy stuff. Use this much money, but no more, to go play your market games. And he was playing some dangerous market games with stock options. And at first he was doing pretty good. He made some money. But then he lost a bunch of money when he got more aggressive. And then rather than stop, he dumped more money than he had permission from his wife into his brokerage account. And then he continued playing these stock option games. And then he lost a ton of money. And what the court basically concluded in that case was he did violate his fiduciary duties with his wife, because she drew a line in the sand and she said, look, here's the line. This is our money. Don't cross it. He crossed it and then lost a bunch of money, and the court held him liable for that additional sum of money that he lost. The McTierney case also lets us know that consent is important. It should be obvious that you should ask for consent from your spouse before you start making big moves with money. In that case, husband wanted to pay off some bills. So he took some money out of the retirement account and paid off some bills, and wife didn't want the bills paid off. She wanted the gains on the account, and the court agreed with her. They said, you know what? Violated the QDROs, you know, so we're going to give wife the rate of return that the community would have enjoyed had you left the money in the retirement account instead of yanking it out and paying off these community bills. So I think it's important, especially during these times, to counsel your clients. Look, you don't get to just play with the money and do whatever you think the tea leaves are telling you is going to happen tomorrow. Talk to your ex and say, look, I'm thinking about doing this with the money. And if you're the out spouse, if you're the non-account holder, I think it's important to put your views in writing too. Document it. You know, send an email to the account holder and say, look, you know, I'm okay with our money being in a bond index, but keep it out of the equities market. I think they're going to crash. And so I think as long as there's a two-way street with sort of at least the communication, you're okay to sort of adjust the portfolios. But I think these cases are instructive of what risk there might be out there for an account holder who decides to make some big moves, or maybe a non-account holder where they can sort of draw the line in the sand by speaking up and avoiding a move that they consider is too risky being made by the account holder, sort of having some sort of recourse, some sort of remedy with the court if you document that. So it's important to counsel clients on that. Okay. The other thing that occurs in my office, I'm sure it happens in your guys' office too, is sometimes clients come to my office and they say, okay, here's the deal. This is what we want to do. I'm going to take all the Google stock. You give her all the Microsoft stock, and that's how we're going to handle it. And so, you know, my response to that, first of all, is, well, you don't get to make that unilateral decision. First of all, if the two of you agree with each other, I'll do it if I can. Right. So if it's like an IRA account, a lot of times with the IRA accounts, they make you list out the individual ticker symbols, and you could say 100 shares of this, 100 shares of this, you know, 50 shares of this. You could do it like Boeing VIP plan. You could do that too. But a lot of the plans, it's just, I can't even do it. So like a Fidelity account, most of them I'm literally, I'm picking boxes on Fidelity's website for what they allow me to pick. And it's not a button on my Quadro machine that I can push to say, send these stocks this way and those stocks that way. And so I think that at least with that sort of attitude, you need to be, as a family law attorney, don't try and write too much instruction into that marital settlement agreement of what sort of mathematical backflips you want me to do before asking me ahead of time if it's possible. That's number one. Number two, a topic that I want to bring up, and I think you guys both have experience with this, so I'd love your commentary on it. These brokerage account windows. John, could you describe what that is, first of all? What a brokerage window and like a 401k account is? Just what is it?
Yeah, so it's basically an investment vehicle that's still within the 401k plan. So it's still part of the 401k plan. If you look at the sort of the master 401k statement, you will see perhaps it'll say Schwab PCRA, and it'll just be listed as an investment. But that's actually money that has been moved over to, say, Schwab, and held in a separate account called the brokerage window. And it basically is designed to have a little bit more broad investment options than you may have offered in the
like penny stocks. Should I advise people to invest in a lot of penny stocks and options on penny stocks these days? What do you guys think? Would that be a good idea?
I'm going to say no. But it is important to understand, I think, with the cases that you've just talked about, just because an investment has gone down doesn't mean there's a breach of fiduciary responsibility.
Right.
You know what I mean? It's like we all lose money, we gain money, whatever the case may be. So, and generally in a retirement account, and David, the case you were talking about, I mean, like if you're talking about just a 401k, or even if it's a 401k with funds and a brokerage window, you still have a more stringent, investment selection than if you just had a straight up brokerage account that,
right.
That you were flagged, to permit futures and options trading.
Yeah, I'm trading pork bellies, baby.
Right. Yeah, right.
Yeah.
Yeah. And I think at least my experience with some of these brokerage windows and some like SEP IRAs and stuff, they put some really weird stuff in there. Sometimes they'll put houses in there and real estate investment trusts, and sometimes they're just not liquid. So the other thing to keep in mind is whether or not you can actually divide the asset. I mean, if you stick a house inside a brokerage window or inside like a self-directed IRA, and then you flip it over to, Rick to say, hey, Rick, divide this account. I think you're going to have to, Rick, correct me if I'm wrong, you're going to have to sell the house first.
Yeah, generally speaking, yeah. And had a discussion on this with unliquid assets, and especially real estate in, say it's the business for husband and wife.
Right.
And they may have one or two employees, but, essentially it's their money, and they, buy real estate and put it in there. Well, that's almost always going to lead to a prohibited transaction, which disqualifies the plan.
Mm-hmm.
So you may not even want to touch that.
Yeah.
Right. Until they sell the real estate. Because if they disqualify the plan and everything's suddenly taxable, they're going to look around to sue everybody that was involved.
Right.
And I've done some tracing work on self-directed IRAs that had real estate, and you will see money coming out of the account to pay for upkeep and and it's like
exactly.
It becomes a nightmare. One other issue on the brokerage window stuff, just sort of like a FYI is, the brokerage window money has to be accounted for separately. And that money has its own statements. So again, if you have money that's in, the 401k plan, and then some of that is transferred over to Schwab because it's in the brokerage window, they're going to be Schwab statements just for the brokerage window. And I've seen a lot of people think that that is the entire 401k plan. That's only the brokerage window funds. So there could be more in the actual. So you want to make sure you're looking at the actual 401k statements. And then Rick, you kind of saying like, husband and wife have a company, they're both participants in the 401k plan. A lot of times parties will look at the master trust statement, which has both of them as participants. It's like, these are separate accounts. Now you're looking at sort of like, with everybody in it.
Oh man.
Yeah.
What a mess.
Yeah, it can be a mess. It can be a mess.
Yeah. So let's, we're going to transition into questions in a minute here, but we have a couple more topics we want to hit before we go over the questions that we received. So first of all, I want to talk with you, John, about discount rates and actuary reports. So my question to you is, if I had one of my clients hire you to do an actuary report like a year ago, or 6 months ago even, or maybe even January, pre-coronavirus attacking the world, is that still going to be an accurate reflection of value today? Is it okay to just still use that, or should they be calling you and updating those reports like they're updating the separate property tracings? What's your call on that?
Yeah, I mean, I would definitely say update, and again, if they had been considering offsetting a defined benefit versus a defined contribution, it would be, well, you could update, but you also might want to just rethink the whole original agreement. But that's for them to decide. But I definitely think, like you said, even just going to January, early February. I mean, that's like going back 5 years. It's just crazy. So yes, I definitely think if you have an actuarial report, you should probably have that updated. Just like you would want to have any kind of defined contribution 401k tracing updated.
Right.
It's just better that way.
Yeah. So I want to hit a topic that Rick feels is important to share, and that is these health insurance issues, whether you're doing a legal separation or a divorce. I think there's some misinformation out there, some fake news. Rick, can you correct us on some fake news on these?
Yeah, I get these coming across my desk all the time where, it's a judgment of legal separation. And the first thing I ask them is, why did you do a judgment of legal separation? And 90 some odd % of the time they say, hey, we wanted to keep her on the health insurance. Well, by the way, judgment of legal separation is also a triggering event for COBRA, which means that she no longer qualifies. You have to go the 36-month COBRA. And people don't really understand the whole concept because they believe that because we're still married, she should still qualify. This is enforced by the employer, not the plan. So if you believe, because not all employers automatically trigger COBRA on a legal separation.
So you got to test it on a case by case, then, Rick, huh?
Right. So you need to have them if they, hopefully you get it before it's actually been entered with the court. But if the clients say, hey, I talked to whatever our insurance carrier is, and they say, hey, we're fine, they need to talk to their employer or HR and get a letter. I need something
in writing. Yeah, right.
Get it in writing. So the way that you can do it, if you really want to do this, go ahead and do the judgment, divide up everything. But then there's a little box that says, reserving jurisdiction over status. Okay. That means you're still married. There's no judgment that cuts off. The problem is it doesn't cut off potential third-party claims. So if you're getting divorced because somebody
running up credit cards,
exactly, or is in the position where they're one of them's ill and they're going to run up a bunch of medical bills.
Right.
So this is a possibility. I'm just trying to get, and I said I'd do this in every presentation I do to family law attorneys because we see it so much.
Right.
Anyway.
Right.
How are we doing on time?
We're doing good. I want to say one more thing, and then we're going to have to jump right to the questions to make sure we're still in that window. So one other thing that I know I do, and I know I've seen you do, Rick, I think I learned it from you actually, was when one party doesn't pay half their QDRO fees, sometimes we're able to bake in to the QDRO itself, increase, say give wife 50% of the 401k plus $500 to offset the fact that husband didn't pay his fee to the QDRO attorney, and so wife had to front the cost, but the judgment orders it split. Now, the case that I rely on is the intermarriage of Tice case. Tice case was, there was a child support QDRO, and the judge essentially said the attorney's fees that were basically expended for enforcement of the existing child support order could be baked into the QDRO itself to collect those fees back. So I'm not making this up, and Rick's not making it up when we do
Well,
this.
here you got to be somewhat cautious on that, because really the only thing that's been approved to have attorney's fees paid out of a quadro is money spent attempting to collect child support. So if you're going to put it in the quadro, it's an equalization.
Right.
It's an
Right.
equalization. It's not attorney's fee.
Don't say it's the labeling is important.
Exactly.
The label is important. Yeah. So
It's an
if you're gonna,
equalization.
So if you're gonna do it ahead of time with family law attorneys, you're
Right.
gonna write it in the judgment. Do call it a global equalization of debits and credits, and that will work.
Yes.
But like for a quadro attorney, I know that what I do to make the universe fair, I bake it in because it is enforcement directly related to the quadro itself.
Right. And what I usually do is so the person that doesn't have the money, I usually say, this is what we're going to do. That way you don't have to come out of pocket. Because everybody that comes out of a divorce, I'm so broke, I can't pay attention, that kind of thing. So, this is a way to be able to get it done. The other party pays, they get reimbursed through the quadro. So
I've had conversations with attorneys, Rick, and I want to know how you handle this. This is how I handle it. If the attorney says, hey, I'm owed $5,000 in attorney's fees, can we get it out of the quadro? What I say is I say, well, an alternate payee can be a spouse, former spouse, child, or dependent of the employee spouse, so that can't be an attorney. However, we can list your address for the alternate payee, say care of, attorney John, and then when the paperwork for the distribution is delivered, it's going to be delivered to the attorney's office. The attorney calls the client in their office to fill out the paperwork to ask for the check distribution. The check is delivered to the attorney's office. The attorney calls the client into their office again, flips over the check, asks the client to sign the check over to them. Attorney deposits the check into their attorney-client trust account and then distributes the funds. That's what I've been saying. Do you do something similar, Rick, or do you have a different procedure for that?
Yeah, no, and the problem is there's got to be some trust, because the alternate payee can at any point in time call up the plan and go, hey, I've changed my mind.
Address for my check.
And here I'm filling it out online, and here's my account number, and tracking and whatever. So you just have to warn the family law attorney that they better still have a pretty good relationship with that client.
Right.
So
I think now is an excellent time to transition to questions. John, you want to pull the questions up on screen, and we'll answer questions and wrap this up. So the first question is, what happens if CalPERS goes bust? Now, Rick, you wrote the chapter on CalPERS in the CEB book. So what's your opinion of this?
If CalPERS goes bust, we're all in trouble. It's the largest pension plan in the country. And in essence, if they go bust, it means the whole state went bust, and we're the 7th largest economy in the world.
Right.
So there will be something that gets worked out if it gets to the point where, the California rule basically says once a benefit has been given to a state employee, it can't be taken back. But there will be something that will have to happen. It's not going to just go bust.
Right. Well, I think what we're, kind of what they're already addressing is PEPRA, right? So the pension reform, so you're just going to see a less generous benefit for future employees.
For new employees, higher taxes for everybody living here.
Right. More employee contributions.
More employee contributions. Yep. Okay. So our next question, in a pension, shouldn't the quadro be based on the payout, not the contribution? John, our valuation expert.
Yeah, just what we were saying. I mean, you want to base it on the monthly benefit that includes employer contribution. So the whole thing, not just what the employee had paid into it.
Yeah.
That assuming that's what the question was focused towards is the difference.
Right.
In the plan. Yeah.
The next question: how do you suggest we divide a defined benefit with fluctuating market and time rule? So. I'm not sure exactly the focus of this question, but I think, you divide most defined benefit plans by time rule, and you divide it sort of at the time of payout. So it's the fluctuating market doesn't really impact the defined benefit plans so much in terms of payout, because they're more contractually formulated. They actually have formulas that are not connected to the market. So you're more concerned with fluctuating markets with 401ks and IRAs accounts than you are with defined benefit plans when you're considering sort of the payout portion of it. Please reiterate in your new recording the discussion regarding repayment to the spouse, monies paid to the employee spouse during the period of separation, methods how this can be accomplished. Okay, so this is a situation where husband comes into Quadro Prepare's office and says, hey, I retired 5 years ago and the judgment was 5 years ago and I've been collecting 100% of the checks for the past 5 years. And I say, well, your ex-wife may want a portion of those checks for the past 5 years. She's probably not going to let you keep those payments for the last 5 years. And probably it's pretty obvious to her that she should have been paid that money for the past 5 years. So the question is, how do you handle it? One of the ways you handle it, from my perspective, is if a lot of pension plans have a companion account. So if by the time you're doing the Quadro, the pension's already in pay status, you're already missing monthly checks to the non-employee spouse. And so if you add up the amount that needs to be paid out, and then you do an equalization out of the 401k plan. So you say, I'm in arrears 20 grand from the CalPERS pension based on the payments that have been made that were not shared with me. Okay, well, let's increase your payments in the deferred comp by 50 grand, get you paid back one time. But maybe you don't have a defined contribution account. What are the other options, guys? What can you do? John?
Well, I mean, obviously you can up future payments to the alternate payee by some amount to make up for the back amounts.
So increase the percentage of the pension payout?
Correct.
Right.
Correct.
Because what you'll see is on a lot of these, especially the public pensions, I mean, if it's been 5 years or 7 years and, they've been collecting $8,000-$10,000 a month. I mean, the arrears amount may not be 50,000. It might be 400 or 500. I mean, it could be a lot, So once you figure out what the interest is in the past payments, you may only be left with one viable option. And that is, well, the only thing left is the pension going forward. How do we do that? So we can sort of bake into the cake actuarially by increasing the former spouse's percentage interest in the future payments. Again, it's based on, average life expectancy, all those things,
Mm-hmm.
So if they have a 401k or 457 that you can tap, that would be, I think, the way to go because they get immediate access and benefit of the money versus getting a little bit over their lifetime. But
right.
It's entirely possible, and we do that all the time. So yes, you could do that if that's what's left. Yeah.
And then another thing to keep in mind on this is because I see this where the judgment got entered not very long ago. We do the Quadro, and then the alternate payee says, hey, wait a minute, he's been collecting, we separated 5 years ago, and he's been collecting this the whole time. I want those back amounts. Well, look at the judgment and make sure, because there's usually a standard waiver of Watson-Epstein and things like that in the judgment. And part of the reason they do that is, I've talked to family law attorneys and they have a 2-day trial on Watson-Epstein credits, and somebody ends up getting $8, once everything's done, and they spent all this time. So that's why you get those waivers. That would take care of any arrearages up to the date of the judgment. So
right, that's a conversation that I've had with family law attorneys where I say, well, is the arrears tracking from date of separation, date of judgment, date they moved out of the house, some other date? I don't wear the black robe here, so you got to tell me, and when I have two pro pers, Rick, what I do is I got to do some bright line rule because I'm not the judge. I just go by the judgment date and I say, probably you assume that you were supposed to consider all debits and credits as of the date of judgment. So we'll just count it from that date. Unless you have some compelling reason to use another date, fine, let's talk about it and see if both of you are on the same page. Or courtroom doors are right over there. You want to walk back through and get a clarifying order for me, go right ahead. So, yeah. Last question, as we run out of time here. For defined benefit plans, how does the alternate payee get the benefit of the much higher income level payout if employee had a much lower income at the time of date of separation? Or is that accounted for in the calculation? Rick, why don't you take that away? The case, the Lehman case.
Yes, Lehman kind of says a bright line that the alternate payee is going to get her share based on the time rule. I'm being sexist, his or her share, based on the time rule of whatever's paid out, however it's paid out, whenever it's paid out. And the way I try and explain this to the employee who's bitching about how he was only making, next to nothing when they were together and got all these promotions afterwards, is that, hey, all of your service credit is getting paid at your high comp, including yours that was back then. So hers is also going to get paid at that high comp. And you just have to understand that it's all equal. All the credits are treated as equal.
Right. Yeah. The thing that I tell them is I say, look, another way to interpret it is if they work 20 years and you're married to them for 20 years, they're never going to get, your ex gets 10 years of service credit. They're never going to get any more, but the 10 years of service credit are going to be worth more because they get the enhancement as well as you do. And I tell them, California follows this sort of marital foundation theory where you would not have been able to move up in your career later on if you didn't build that base career that was created sort of during the marriage. And so, maybe if we were in Texas, we'd be having a different conversation, but at least in this state, the former spouse gets the enhancement. John, did you have something to add to that?
Yeah, I was going to say, that's just momentum, right? So as they're working and they're building these building blocks of their career, I just tell people a rising tide lifts all boats, right?
Mm-hmm.
It's the salary increases all years are going to be more valuable. And
Right.
California, by applying the time rule, is saying that all years should have equal value, regardless of when they were worked or when you were married.
Yeah. So we're going to conclude our presentation. Just a reminder, the code for the MCLA is Rick, Dave, John 2020. John, why don't you splash up our contact information? Clean. That's right. Because it's Rick, Dave, John 2020 clean is the code for this presentation without all the hacker trolls. John, in case somebody needs to get a hold of us, where they can reach us here. And we thank everybody for taking the time to listen to this new clean presentation without the trolls. And be safe out there and wash your hands. And that's a wrap, you guys.
All right.
Thank you.
Take care. All right.